And now, just a brief re-biography of our two speakers. Michelle Morado-Itkowitz is an attorney specializing in residential and commercial landlord and tenant law in the city of New York. She's been doing it for many years. I'm not going to say how many. She's also very experienced in general commercial litigation and all manner of real estate transactions. Michelle publishes and speaks frequently and has taught for many different organizations and venues. She's also currently co-authoring the New York State Bar Association, New York Commercial Landlord and Tenant Law and Procedure book. Jay Itkowitz is the founding partner of ITKOWITZ PLLC, specializes in sophisticated commercial litigation. He's a litigator, strategist, and trial lawyer, and has approximately 30 years, I don't think he minds if I say how long, 30 years in almost any type of litigation transaction relating to real estate. And now I'd like to introduce Michelle Itkowitz.
I'm Michelle Itkowitz. My firm is ITKOWITZ PLLC. We do all kinds of We do all kinds of real estate litigation, and we're located in Manhattan, but we work all over the place. I could be talking, the way I'm going to do this is I pulled a bunch of recent interesting cases that affect appraisers. So I'm going to do it sort of law school-like. We're going to talk about the facts of each case and then the arguments the lawyers made and how the court decided and why, so that you can really understand to see your appraisals in action. Because I assume most of the time, if you do your job right and people leave you alone, you do the appraisal and then it's done. And maybe you see, I think, a little bit more of the impact appraisals have when something goes wrong or someone alleges something goes wrong and there's litigation. So the thing is, if I'm talking to you about how a case comes out and you have real life experience about a certain issue, please raise your hand and let's discuss it, because I think it'll be better that way. This gets a little confusing. The court of original jurisdiction, the first level court, the court that you would go to with almost any normal lawsuit, is the Supreme Court of the state of New York. And it gets confusing because on the federal level, obviously, Supreme Court means the highest court. In New York, it's the lowest of the three courts. And then you have some other courts, your village courts, your city courts, your New York City civil court, surrogates court, family court, but whatever. Basically, appraisers, a lot of the litigation starts in the Supreme Court. Then, if you don't like what happens in the Supreme Court, one or the other parties can appeal up to the appellate division of the Supreme Court. And there's 4 of those. The second department's Brooklyn and Long Island. The first department's Manhattan and Westchester, Jay? First department?
Yeah.
Okay. Third and fourth are upstate. Then, if you have the right to appeal from a decision that one of the 4 appellate divisions give you, then you can go up to the one biggest court in the state called the Court of Appeals, which is in Albany, which again is confusing because Court of Appeals on the federal level is that second level, and then the Supreme Court's the top. So just forget that. So when I talk about a case in here, I tell you what court it's coming from, because this is what's important to know. The higher the court, the more authority that decision has. The first case is on page, oh wait, I wanted to say something about the USPAP. Do you call that the USPAP?
USPAP.
USPAP. I was going to say, you must have like an acronym. USPAP. Okay. So, this comes up in most cases. It's the Uniform Standards of Professional Appraisal Practice, and it's the quality control standards for real property and other kinds of appraisals. And this came out in the 1980s after the savings and loan crisis. The Appraisal Foundation, which is a nonprofit organization, made the USPAP. So, that comes up a lot. I just wanted to mention it. Okay, this case is Kostrich v. Ciota, and it's Supreme Court, Westchester County. So again, it's a lower court, and it's from last August. And this is why this case is interesting. So it was a homeowner was trying to refinance, and the bank said, you have to use this appraiser. So the bank hired the appraiser, and then the homeowner didn't like the appraisal and didn't get the loan, so they sued everybody, including the appraiser. So this is pretty standard language you see in the middle of page 6. The appraiser was being sued for breaching the duty to the homeowner by failing to exercise reasonable care, skill, and diligence, and performing their appraisal report as an ordinary, prudent appraiser an appraisal company would use under similar circumstances. So you see that a lot. That's when an appraiser gets sued, that's what they say you did wrong usually. So they also said that these appraisers didn't use accurate or appropriate comparables, that they didn't conform with the uniform standards of professional appraisal practice, and that due to all this negligent preparation, that the appraisal came in $200,000 too low. So, this is what the appraiser said to defend himself. He said, homeowner, you can't sue me. I didn't have a contract with you. I didn't have a deal with you. We had no privity of contract. So what's privity of contract? Black's Law Dictionary defines it as the relationship between the parties to a contract, allowing them to sue each other, but preventing a third party from suing. So if you two guys have a contract and you breach it, but that somehow damages you, you can't sue him because you're not part of the deal. So that's what distinguishes often real property law, where sometimes rights can run with the land. So let's say you have an easement. As you know, the easement moves with the land no matter who owns it. But with contract, you have only the parties to the deal are who you have a responsibility to. So here's, I'll tell you another interesting thing about this case at the end, but the clever little argument that the lawyer came up with. So the lawyer said, well, I know I'm not in that contract. I know I don't have privity, but I have near privity, because in the law there's always the rule and then there's the exceptions, which are really why I have a job. So near privity. So near privity means that there was an awareness by the maker of a statement that it was going to be used for a particular purpose, and then reliance by a known party. That would give rise to near privity. And the lawyer referred to another case called Fortress Credit versus Deckard, which in that case there was a lawyer giving an opinion letter about a loan, and a third party sued, and it was allowed to sue because there were near privity. So he said, look, I got you. But this court said, no, no, no. The appraiser is off the hook, and I will tell you why. It is clear from the language of the appraisal that plaintiff could not reasonably rely on this appraisal. The appraisal specifically said a borrower or a third party may receive a copy of the appraisal. However, it does not mean that the borrower or third copy is an intended user. The stated purpose of the appraisal was solely to aid Fairway in performing its assessment of the plaintiff's loan application. Further, plaintiff did not rely on defendant's appraisal. This is the funny part. The homeowner said, I don't like this appraisal. I contest it. She contests it in writing with the bank, then goes out and brings in her own appraiser. So the point is, the idea that she's suing the appraiser because she relied on his appraisal is crazy, really, when you think about it. So, so the court said here, no. I think what's interesting about this case and why I led with it, because, I mean, it's kind of a good holding for appraisers. It's if you get sued by a homeowner because you do an appraisal, you're hired by a bank. If you're working for a bank, yes, your appraisal probably does say this is only for the bank.
Well, there is...
Or it should, is what I'm saying.
There is typical verbiage in the small print in most appraisals, as everyone here knows, either in the scope of work or if it's a Fannie Mae form as part of the certification and contingent or limited conditions to that effect. But I think what's really important about this case is the appraiser added to that standard phraseology and put in page 2 on the appendix, top right, a borrower or third party, as you said, may receive a copy. It does not mean the borrower or third party is an intended user. I think it's incumbent on every appraiser to protect themselves with this specific wording in every appraisal report. Since I saw this case, every appraisal that we do has that statement in it, because it takes the standard statement, the certification of limited conditions, to a very specific point, protecting the appraiser. And I think that's why we won this guy.
But the bottom line is, I noticed that. If you look at the name of the lawyer, it's Jeffrey Kostrich, and the plaintiff is Diana Kostrich, and there's nothing more dangerous than like your kid has just got his law degree and doesn't have a job. I mean, that's what I'm imagining this was, I don't know. If anybody knows them, I'm sorry. But like to me, but I think that's also significant because the point is, on some level, this is a stupid case that somebody had to defend against. I mean, it's not even, pretend the language wasn't there. She didn't depend on this appraisal. She asked for another one and she disputed this one. So it's not like there was some kind of, well, thank God the court agreed. Now, there's gonna be a case called Roden we talk about later where a different result came out because there was somewhat of a different relationship with the third party and there was somewhat different language. But I was gonna take it out of order, but I'm not gonna. I'm gonna leave it for now. But, so that's a pretty good case for appraisers and that's pretty good language to include. Okay, it is clear from the language of the appraisal that plaintiff could not reasonably rely on the appraisal. The appraisal specifically states a borrower or third party may receive a copy, however, it does not mean that the borrower or third party is an intended user. All right.
Nor does it establish a relationship between the appraiser. That's what I have in mind.
Yeah, I think that's the,
Just because they're holding a copy does
Right.
not establish a client.
right. Like I said, if these two guys are fighting and something happens, he can't sue on it if it's their deal. All right, so the next one is on the bottom of page 7, Sutton v. Hafner. This case is just kind of, in a way, a little funny, and I don't know that there's any huge takeaway, but, so the plaintiff was a litigant in a partnership and corporate dispute. Okay, so there was a lawsuit, and they needed an appraiser to testify in the litigation, and they hired this guy, and his curriculum vitae said, I'm a certified general real estate appraiser. I received a Juris Doctorate degree, so he was a lawyer at one point in 1981. I have litigation consultation development in 15 listed contexts, and I'm qualified as an expert witness in Supreme Court and the Public Service Commission. So he had a nice resume. So shortly before this, oh, by the way, this one is, it's funny, this is Appellate Division 3rd Department, so somebody, again, appealed this. In this case, somebody actually took an appeal to get to this result. Right before this guy, this appraiser, was supposed to go on the stand, they found out, he told his client, by the way, I was disbarred. So yes, I was an attorney, but then now I'm not an attorney. So the party got all mad and said, well, that's not gonna look good for me using you as an expert witness. So this case is about the party suing the appraiser for his fee back because he messed him up as an expert witness. But it's interesting what the court said. And this, I mean, maybe I shouldn't have even included this one because I don't know if there's a huge lesson here other than don't lie on your curriculum vitae or don't leave out important information. But ultimately, the court said this appraiser deserves his fee because it was your job to investigate what his background was, and it was your job to, and plus he gave a good report. So, I mean, when you hire an expert, you're hiring an expert. It's your job to look into who they are and to investigate it. This wasn't some kind of legal wrong that's actionable. So, anyway, you want to do Noble?
No, I just want to say, this case probably wouldn't happen today. Let's see what the date is.
No, it's a new case. It's 14.
But in the era of Google, you know, I don't know why the person who was the lawyer who was hiring the appraiser wouldn't have checked out his witness. Whenever you produce an expert witness in any kind of litigation, the lawyer, if he's doing his job, should understand that the expert is going to be subject to an attack. That's the way the system works. So it's incumbent upon the lawyer to check out, in all respects, his expert witness to make sure that that person's going to stand up to a potentially withering cross-examination. And certainly if the appraiser had been disbarred, that might certainly be a subject of interest. However, that doesn't entitle them, the lawyer who didn't do this job, to get the fee back. Yes.
Was it the appellate decision or lower court?
This was an appellate decision.
Okay.
All right, so the next case on page 9 is Novo versus Perales, and it's Supreme Court, New York County, 2014. So, did you want to do this one? Because it's an attorney general case. Let me say this too, and I noticed in my research. There are generally two kinds of cases, and I kind of mixed them up here. In retrospect, maybe I would do this differently, but there are cases that involve appraisers and appraisals in somebody else's litigation, and then there's the attorney general stuff where they're going after the appraiser. And this is more, came out of this, the Department of State was going after the appraiser, and that percolated up into what's known as an Article 78 proceeding, which means it went out of the administrative body into the court system. That's where it gets appealed. Did you want to do this one?
Yeah, I mean, basically, this is a case where I assume it was a fairly large company, where the person who did the actual appraiser had to get it signed off by somebody else in the company, and then somebody determined that the person whose name was used discovered her name and signature had been placed without her knowledge and permission, that she had not seen or approved. So she brought a claim against the appraisers, and that was taken up by the Department of State, and the Department of State revoked the appraiser's license. So this obviously becomes a very serious situation. Presumably, this case resulted with the revocation of the license. The revocation of the license was annulled by the appellate court. But basically, what happens is a license proceeding where somebody is, where the AG or the Secretary of State is seeking to discipline an appraiser, that's what's called an administrative determination. And if they take such disciplinary action against you or against an appraiser, the appraiser has the right to challenge that determination. And the way agency decisions are challenged is by an Article 78 proceeding. In an Article 78 proceeding, basically, you can overturn an administrative determination if you can show that the determination was arbitrary and capricious. Arbitrary and capricious is a very hard standard to overcome because it basically means without reason, that in plain English. So typically speaking, it's very, if the agency, or in this case the Secretary of State, finds that an appraiser violated a duty of care, for instance, or violated a fiduciary responsibility, that's a ruling on the merits. And that's not going to get overturned unless the decision is without reason or arbitrary and capricious. In this particular case, this decision by the Secretary of State got annulled. Why? Because of an error in law. So if the agency commits a violation of due process, there you're not talking about the merits. There you're talking about a legal error on the part of the agency, and that's a much easier ground to get an administrative decision reversed by a court. So typically speaking, when you bring an Article 78 proceeding, it goes from the agency to the Supreme Court. If there's been a hearing where evidence has been taken, then the Supreme Court is supposed to refer it to the appellate division, where it's where the ruling will be tested by to see whether there's substantial evidence to support the determination. However, if there's an error in law, it doesn't go to the appellate division. The Supreme Court is able to reverse it based upon an error in law, which is what occurred here.
What was the error? Tell them the error.
The error was the failure to let the appraisers who were being accused know that their license was at risk. The failure to put them on notice that their license was at risk arguably is a prejudicial error because they maybe wouldn't have treated it that seriously. Somebody might have said, well, okay, so they're saying that we processed an appraisal, put somebody, used the supervisor's signature without that person's permission. What's the big deal? If in the notice it said you're being brought up on charges, and if we prevail, your license may be taken away from you, well then you might go hire a lawyer where you otherwise might not hire a lawyer. So that's why it's a prejudicial violation, and that's why the reversal occurred.
Because they're looking on the film.
But it sounds like there was fraud involved here, and the appraisers committing the fraud had to have known that they were committing fraud.
That's on the merits. You're talking about what we call the merits.
Okay.
So we don't get to the court didn't get to the merits
But
of it
the point
because of the procedural violation. Now, that may or may not be true, but it also could have been accidental. In the sense that when you have a supervisor, the supervisor leaves, maybe the supervisor worked on it, but didn't sign it. So maybe somebody said, okay, the supervisor was working on it, and we have a stamp, we put a stamp on her, on the appraisal. I'm not defending it. I'm not defending it. I'm just saying that, or it could have been accidental, or it could have been signed before she left. Who knows?
Okay, well, it seems to a couple of things. It seems to me, former employee of the appraiser signed off on appraisals, plural. So therefore, it's an ongoing process. The person that signed off was not there anymore. So someone else took the initiative
To put that person's signature as a supervisory appraiser, when in fact that was not the case. They were not the supervisory appraiser. So the person doing that fraudulent act, according to my knowledge of USPAP, we all know that that's fraud.
Right.
We all know that you can't do that.
But this case came down to the state put them on double secret probation.
Well, it seems that the state, if I'm reading this right, it seems that the state let them off because they weren't, the appraiser were not warned that their licenses were at risk by their own behavior. The appraiser is supposed to know already, according to USPAP, that behavior is illegal. I don't get it.
That may be so. That it may be a complete violation of USPAP. However, what the court was saying was that the agency, in initiating the administrative proceeding against the appraisers, had a duty to warn the appraisers that their license was at risk. The failure to warn them that their license was at risk, even if everybody in this room might understand that. It reminds me of like the Miranda warnings. Everybody who's watched TV knows that when you get arrested, the cop is supposed to say, anything you say may be used against you. So why do we have to worry about that? However, the Supreme Court has said, if you don't give that warning, the whole arrest gets thrown out. No matter what that person has done, if he admitted something, okay, without getting warned, no matter what he did, he gets let go. And you can't use that evidence. This is the same thing here. The court is saying that if the agency, just one second, if the agency is bringing an appraiser up on charges, or in fact a teacher, or anybody who's subject to licensing requirements, if the agency doesn't warn the person who's being charged that they could lose their livelihood if they're found to have committed this indiscretion, then the determination can be invalidated. Yeah.
since this ruling, has the state amended their notices on these Article 78s to include that possibility? Or do they still send out these notices that could be overturned?
You know something? One would presume that the agency has modified its procedure. That's kind of the way the law works. A lot of times, people don't think of a possible result, and then somebody brings a case, and then behavior changes. I remember when I started my legal career, my private career, in 1982. It's hard to believe that it was that long ago, but I feel as fresh as I did in 1982. I was representing a tenants association on Roosevelt Island, and they were challenging a rent hike for a Mitchell-Lama program. And the agency completely violated all the rules and regulations it had promulgated in administering that rent hike. So I was hired. I looked at this. I saw that they completely violated their own rules and regulations. I brought an Article 78 proceeding. I got the whole rent increase for the whole development thrown out. After that, they changed the way they did business. They didn't appeal it. It was a Supreme Court case. They realized that they were wrong, and they realized that they want to get a rent hike, they've got to follow their own rules and procedures. So that's typically the way the law works. If somebody makes a mistake in an agency, they're called to task for it, and behavior changes. That's the beauty or the curse of the court system, depending on whether your ox is being gored. Yeah.
If the administrative proceedings wouldn't they have to tell you what the penalties would be for doing the infraction?
Well, that's what this
Otherwise,
case is saying. That's what this case is saying, is that when you bring up the charges, it's kind of like in real estate, when you serve a rent demand, or when you serve, let's say, a holdover proceeding, you say, if you lose this case, you're going to get evicted. Okay, so somebody reading that knows what the consequence is if they lose. Here, what the court is saying to the agency, if you bring somebody up on charges and you revoke their license, you got to tell them. No. Well, this is Judge Schlesinger, Michelle is saying, should I mention it's Judge Schlesinger? She says Alice Schlesinger. She's, the Elizabeth Warren of the Supreme Court of the state of New York. She's very due process oriented. She's very tenant oriented. And she was here. She was protecting the rights of people who had their livelihood at risk.
You know what's interesting too on this one? Wait, we got another question.
I was just going to say that I read an article about this, and I think it was in the Real Deal or someplace like that, Curve, but they ended up, the state went back and revoked their licenses. And I think it's under appeal now.
But that's what I was going to say. I looked for whatever, as of when I did these materials in January, I looked in the Westlaw and Lexis to see, well, what's round 2? But this being a pretty new case, 2014, I don't know what round 2 is. So from what I could see, I couldn't tell whether they gave up, settled, did the proper thing and came back and revoked their license. So you saw something where it did revoke their license?
Yeah, they went back and they took the licenses because when they were accused of fraudulently signing an appraiser's signature to something that the appraiser never did.
Right.
So they went back after them, and that was under appeal again.
So I think if there's a takeaway, because I like to end every one of these things with a takeaway so that it's useful, is here's another thing I can't tell from a lot of these cases. I can't tell if an insurance company is defending the appraiser a lot of times or if they have private counsel. Because if your insurance policy covers you, first of all, I assume all of you know, if somebody accuses, if you are on notice that somebody's going to sue you, you let your carrier know. And they may or may not cover you. So I can't tell who is defending this appraiser, but the legal question for people like us is, why bother getting the technical knockout if they're just going to come after you again? I think you want to take that one? Because that's your kind of thing.
Well, look, the people in this particular matter were defending their livelihood. So once they realized that their license was revoked and their ability to make a living was revoked, they're going to fight for their license if they have any conceivable chance of winning. So they got it knocked out. And then, as this gentleman says, the state went back. But in the course of litigation, there's always a chance to potentially settle the case, and it depends on the varying temperaments of people involved. Litigations can have a life of a number of years, so it depends on the persuasiveness of your lawyer, the determination of the other side, the nature of the evidence. All of these things come into play. So, for instance, I've represented real estate brokers before the New York State Attorney General, who've been accused of discriminating against people in the rental of housing on the basis of source of income. Now, if a real estate agent discriminates against a person who's getting FHA or some kind of governmental subsidy and doesn't want to consider a person because they're getting that subsidy, that's a violation of a New York City law, which subjects you to discipline before the Attorney General. And the Attorney General has a range of options that they can employ. They can do a fine. They can seek to revoke your license. So there's a range of penalties that can be imposed. So by getting this reversed, perhaps the lawyer was hoping he'd get a second bite of the apple. Perhaps he was hoping that he was going to get a negotiation going with the Department of State and get a better result the next time. So that would be why somebody would do that.